So friends, two federal court judges just issued orders within minutes of one another, each in a case involving the prosecution of a former president of the United States. And what you can tell about the temperament of each judge by the order they issued? Let's talk about a tale of two judges, because justice matters. Hey all, Glenn Kirshner here. So friends, there's no two ways about it. Trump-appointed Judge Aileen Cannon continues to favor the defendant who bestowed upon her a lifetime appointment to the federal bench. Here is the new reporting, this from Hugo Lowell of The Guardian. Headline, Judge signals she could delay key dates in Trump's classified documents trial. And that article begins, the federal judge presiding in Donald Trump's criminal case related to his retention of national security documents at Mar-a-Lago appeared inclined to delay the scheduling of the trial, expressing concern that the timetable would clash with Trump's 2020 election subversion trial in Washington. The U.S. District Judge Aileen Cannon did not specify what changes she would make to the pretrial timetable at a hearing on Wednesday, but signaled she would make adjustments to certain deadlines, which could have the net effect of pushing back the start of the trial. Trump has made it no secret that his overarching legal strategy in his criminal cases is to seek delay, ideally beyond the 2024 election in November, in hopes that winning re-election could enable him to potentially pardon himself or direct his attorney general to drop the charges. The prosecutors in the office of Special Counsel Jack Smith explicitly complained to the judge that Trump's request to postpone some deadlines because of complications with the discovery process under the Classified Information Procedures Act amounted to a request to delay the trial. But the judge concluded the hearing by saying she would enter an order as soon as possible outlining reasonable adjustments to the timetable after repeatedly mentioning that she believed the delays in turning over the classified discovery to Trump's team would cause the cases to clash. This quote from the judge, "I'm having a hard time seeing how this work can be accomplished in this compressed period of time," Cannon said. And friends, when I read that article, it prompted me to post the following. Trump's documents obstruction espionage case may very well suffer death by 1,000 Cannon continuances. Okay, friends, let's take on a tale of two judges, because Judge Cannon and Judge Chutkan issued orders on Wednesday within minutes of one another. These were sort of routine orders resolving some fairly routine, even mundane legal issues. Judge Chutkan's order, 5 pages, short, sweet, to the point, no muss, no fuss. Judge Cannon's order, 15 pages long and filled with criticism. Criticism of who? Special Counsel Jack Smith. And friends, it's not just criticism. At times it feels like gratuitous criticism, sort of bordering on snarky. Let's have a look at just some of what Judge Cannon says in her 15-page legal ruling. On page 4, regarding an argument made by the Office of Special Counsel, Judge Cannon says, quote, "The court cannot agree with this broad and atextual interpretation, which, although presented as supported by the statutory text of SEPA, really amounts to an expedient reading of Section 3 that is at odds with its plain meaning." That would be slam number 1. The Office of Special Counsel attempts to maneuver its way around the plain meaning of Section 3 and the surrounding sections. Its argument lacks merit. That would be slam number 2. Although the Office of Special Counsel offers a handful of non-binding examples, those instances do not displace the foundational principle undergirding Rule 16, slam number 3. This argument from special counsel creates the impression of plausibility, but is unpersuasive. Slam number 4. Yet the Office of Special Counsel's complicated interpretation of this key word invariably generates additional convolution. Slam number 5. Then she finds there is yet another strong signal to decline the Office of Special Counsel's reading. Slam number 6. The text of SEPA does not support the Office of Special Counsel's position. Number 7. Office of Special Counsel offers a broad and unconvincing theory. Slam number 8. The court is not amenable to distorting the provisions of SEPA because the Office of Special Counsel considers its preferred process more efficient. Slam number 9. Should I go on, friends? Judge Cannon, your bias is showing. You know, friends, let's go back for a minute to the federal law that talks about what should happen, what must happen when it seems like a judge might be a little bit partial to one party, a little bit biased, when their impartiality can reasonably be questioned. The law, which we've talked about before, is 28 United States Code Section 455, and it sets out the standard when a judge must recuse themselves from a case, must remove themselves from presiding over a case where they might be a little bit biased. Here's what the law provides. Any justice, judge, or magistrate judge of the United States shall disqualify himself or herself in any proceeding in which his or her impartiality might reasonably be questioned. That, friends, is an extraordinarily low burden. If a judge's impartiality might reasonably be questioned, not that she can't be impartial, but if her impartiality might reasonably be questioned, she must remove herself from the case. She must recuse. When you read this motion, which is just this repeated, ugly, gratuitous, broadside attack on one party, the Office of Special Counsel, where the other party, the defendant, is the very person who bestowed upon her a lifetime appointment as a federal judge. And when you couple it with the appellate court, which previously ruled that Judge Cannon abused her judicial discretion by doing something that acted to the benefit of Donald Trump, and she did it in a way that the law did not allow. And they actually said that she interfered in an ongoing DOJ investigation of the potential crimes of Donald Trump. You put that all together, it so far exceeds the standard for recusal that her impartiality might reasonably be questioned. I mean, reasonable people are questioning her impartiality every day by probably the hundreds, the thousands, the millions. Why? Because she has established a record that gives rise to a reason to question her impartiality. Now, friends, I know the recusal train may have already left the station because thus far, Special Counsel Jack Smith and his prosecutors have chosen not to recuse her, not to file a motion seeking that she first remove herself, and second, if she refuses to remove herself, if she denies the motion to recuse, it would go up to the appellate court, and then the 11th Circuit Court of Appeals, which already mightily criticized her once for abusing her judicial discretion in favor of Donald Trump, might very well say the better course here is to remove her from the case because her impartiality can reasonably be questioned. The reason I'm so disappointed that there has not been a motion to recuse filed is because I think this issue is too important and the evidence is too clear, indeed I would say it's voluminous, that there is a colorable claim, a straight-faced claim, a claim supported by evidence that reasonable people might question her impartiality such that it should be litigated, right? Sunlight is the best disinfectant. Don't make these decisions behind closed doors and decline to file the motion. File it, litigate it, let Judge Cannon decide it in the first instance, let the 11th Circuit Court of Appeals then decide it on appeal, and then we the people could see all of the evidence in favor of recusal and against recusal, and we could perhaps more comfortably live with the decision by the judges, the appellate court judges, that no, she should not recuse. There's not enough evidence. She can be fair and impartial and independent. Her impartiality cannot reasonably be questioned. We could live with that result if we saw it tested in the crucible of a motion, an adversarial motion where all parties could be heard. Then we could have confidence in the decision that no, she will be the judge. She will remain the judge on this case. I think that's unwise in the extreme. I actually think that any time the Department of Justice decides there's enough evidence to criminally charge a former president of the United States, it's absurd to have a judge preside over that criminal trial who was appointed by the very president that's on trial. You can reassign it to another judge, Republican appointed judge, it doesn't matter. But the judge shouldn't be beholden to the defendant for her lifetime appointment. That makes no sense. That screams inherent conflict. At least there's an appearance of conflict. And an appearance of conflict is almost as bad as an actual conflict because it undermines confidence in the criminal justice system, in the trial, and in the result. But as I say, I do think the recusal train may have left the station, and I think it's unlikely Jack Smith and his team at this relatively late stage will file a motion to recuse. I do think Judge Cannon will continue to appear to favor one litigant over the other, Donald Trump over the Office of Special Counsel representing we the people. And I think there is little doubt Judge Cannon will continue to push deadlines down the road, which will result in the May trial being continued for goodness knows how long, but that's precisely what Donald Trump has wanted all along and has been demanding of Judge Cannon all along. So we'll see if she complies with that demand from the very person who appointed her to the federal bench. But you know, we the people enjoying conflict-free judges presiding over the trial of a president who tried to steal our election from us, like justice, matters. Friends, hang in there. Please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.